So it looks like the Supreme Court will weaken racial gerrymandering in the United States. On Tuesday, the Supreme Court heard Merrill versus Milligan, an Alabama redistricting case focusing on Section 2 of the VRA that bars any rule that results in a denial or abridgment of the right to vote on account of race. Depending on how the court decides, Merrill could allow states more latitude to constrain the political power of Black and brown Americans and shrink their access to public resources on the local level. Section 2 of the Voting Rights Act of 1965 prohibits voting practices or procedures that discriminate on the basis of race, color, or membership in one of the language minority groups. So what's at issue in this case in Merrill that they're hearing oral arguments on right now? So in Merrill, the bench is reviewing a lower court opinion from January that blocked Alabama's newly drawn congressional map for likely violating Section 2 of the VRA. That map includes just one district where Black voters can put their preferred candidate in office, though Black Americans make up 27% of the state's voting population. Because the lower court judges determined that Black voters have less opportunity than other Alabamans to elect candidates of their choice to Congress, lawmakers were told to form a second majority Black district or something close to it. One argument Alabama makes is that the harm of the VRA is that it essentializes race. That is, it awards districts to voters based on race and deepens divisions. It's worth noting that Alabama really isn't arguing that the lower court misunderstood the VRA. Instead, the state is asking that the Supreme Court reimagine the rules governing Section 2 claims. So that's a very interesting case that could result in us having districts where Black votes are diluted in the United States of America. Meanwhile, another Supreme Court case could weaken unions' ability to strike in the United States. The case is Glacier Northwest versus the International Brotherhood of Teamsters. It revolves around a 2017 labor dispute involving unionized drivers at a concrete company in Washington state. Glacier Northwest filed a lawsuit to force the union to compensate it for ready-mix concrete. It claims the union destroyed intentionally by declaring a work stoppage. Washington State Supreme Court ruled that the strike was arguably protected by federal labor law, and the company's claims should therefore be dismissed, leaving the dispute under the federal NLRB. But Glacier Northwest and conservative groups argue that the federal labor law should not preempt the company's claims and that it should be able to sue the Teamsters in state court, suing them for the damages of money lost because the concrete hardened while the workers were on strike there. The labor lawyer said a Supreme Court decision against the Teamsters could open unions up to lawsuits by employers seeking to recoup costs associated with the strikes. That in turn would make workers more hesitant to go on strike to improve pay and working conditions, thereby weakening unions' most powerful weapon, the ability to withhold labor. And in recent years, the conservative court has not been friendly to labor. So the fact that they've taken this case suggests that things are not going in a good direction for labor protections in the United States of America. In 2018, the court issued a historic ruling making the entire US public sector right to work, allowing government employees to opt out of paying union fees, even if they're covered by a union contract. The same year, the court issued a historic decision establishing that employers can force workers to sign arbitration agreements as a condition of employment, making it harder for workers to band together as victims of wage theft or discrimination. Now, the way this court is deciding on which cases to hear is very political. They're submitted hundreds of cases every year. It takes 4 justices to pick from all of those writs of certiorari, which are basically cases that people think the Supreme Court should hear. They get to decide which cases they will hear. Of course, those 4 to 5 conservative justices on the bench are handpicking cases that will allow them to overturn precedents that will take away our rights. So this is just a brief synopsis of how the court chooses writs of certiorari. Certiorari or certs is generally associated with the writ that the Supreme Court of the United States issues to review a lower court's judgment. A case cannot, as a matter of right, be appealed to the United States Supreme Court. As such, a party seeking to appeal to the United States Supreme Court from a lower court decision must file a writ of certiorari. In the Supreme Court, if 4 justices agree to review the case, the court will hear the case. In June, in his opinion on Roe versus Wade, Clarence Thomas said the quiet part out loud. He basically asked for people to submit writs to the court so they could overturn Obergefell and Griswold precedents. The conservative justice took aim at the court's 2003 ruling in Lawrence versus Texas and its 2015 decision in Obergefell versus Hodges. Lawrence established that criminal penalties for sodomy or private sexual acts between consenting adults are unconstitutional. That decision came down in a 6-3 ruling. Obergefell legalized same-sex marriage in a nationwide, legalized it nationwide in a 5-4 decision. Thomas, who joined the court in 91, dissented in both the 2003 and 2015 Supreme Court decisions. In his concurring opinion with the majority decision to overturn abortion rights, Thomas wrote that the Supreme Court should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. The justice contended that those precedents were demonstrably erroneous. Even back in October of 2020, Justice Thomas and Alito urged the court to fix its ruling on Obergefell. They have said time and time again that they believe these precedents that give us the right to have private relationships and have same-sex relationships, our ability to have an abortion that fall under the due process clause and the right to privacy. They are looking to overturn all of these precedents simply because now they have a majority of 5 justices that do not represent the majority opinions in the United States. And it's been called on time and again for President Biden and the Democratic Party to make the decision to add more Supreme Court justices to the bench. It is disgusting that 5 people can make a decision for 330 million people and take away their rights. That is really what we are at the risk of. Think about how much power corporations have in the United States. If workers lose the right to strike, we will be losing our freedom in this country. And it's been argued that we should have 13 justices on the bench, 1 for all of the circuit courts in the United States. But there's a lot of controversy for some reason about stacking the court, but everything is on the line if we do not. Jackson, what are your thoughts on this?
Well, if Republicans needed to stack the court, they absolutely would. And at the end of the day, it's simply corruption that's kept the Democrats from, achieving simple wins that they easily could have, because the reality is that the Republican Party's been waiting and working for decades to have this level of judicial authority. And with their shrinking generational popularity, they really don't have any time to lose. So they've been going after everything, as quickly as they can, because why wouldn't they? Like you said, these 5 people who are in this position where people really can't do much about what they do. Why wouldn't they do this? So unfortunately, we're at the mercy of these people who really don't care how we feel at all. And several of those people who were just rushed in. Trump got 3 people on the Supreme Court just in his 1 tenure. So this is the result of the ruthlessness and the commitment of the Republican Party and the right wing in this country.
Yeah, I oftentimes think about what will it take to get people in the streets? Because this is very serious what the Supreme Court is about to do. And in 2021, in April, congressional Democrats introduced the Judiciary Act of 2021 to expand the court by adding 4 seats, creating a 13-justice Supreme Court. We hardly see them fighting for that. And we know that power concedes nothing without a demand, but it's not at all sexy to be hey, the Supreme Court's going pretty bad. We should all be in the streets before we lose all of our rights. It feels like it's gonna be too late before the majority of people in America realize this is a problem, because we don't really see this getting coverage on mainstream news.
Yeah, definitely not. And because a lot of the mainstream news, they're giant companies themselves that don't really want to encourage unionization or anything along those lines either. So, like you said, we're getting to a point where our backs are being put against the wall. And, once that happens, unfortunately, the violence is often the result. So hopefully we can avoid a lot of that moving forward.
Yeah, I think that's exactly right. And even if we have this overturning of the precedent that there is federal law that protects workers' ability to strike, if we see this Glacier Northwest case go the other way, we're already going to be at a point where we've lost so many of our freedoms thanks to the Supreme Court, thanks to conservative justices across the country, thanks to lack of action by the Democratic Party. And we'll be in a place where it doesn't really matter if it's illegal or we'll lose wages. We're going to have nothing to lose. And so when you see labor leaders calling for a general strike come 2024, it makes a lot of sense. And I think we are on the brink of violence, but thankfully withholding our labor is really how we get a message across without having to take that final step, really hitting them where it hurts in their pockets and in their profits.